Hello, this is Dr. Mewborn, and this is Religion the Public Square. Our topic for today is the Supreme Court cases that changed America. There were several Supreme Court cases that literally changed the landscape of America as we see it today. And so I want to go ahead and jump into our study today because it is truly fascinating. The first case that we're going to look at is Marbury versus Madison, which was in 1803. And Chief Justice John Marshall established the Supreme Court's role in the new government. And so we're looking way back in our history of 1803, not long after the country was truly established. But we also see here that the Supreme Court has the power to abolish legislative acts by declaring them constitutional. Also, the court has the power to review all acts of Congress where constitutionality was an issue. And so the court has this power to look over the things that Congress is doing, because you have to look at the Constitution of the United States in light of what is going on in the country at the time. And also the Chief Justice John Marshall had the right to define some things. And like what we see here on this plaque, which is in the Supreme Court, it is emphatically the province and duty of the judicial department to say what the law is. And so a lot of times the Supreme Court actually defines for us what the law actually says. And so that's why this is such an important case. It laid those things out to help define what the law really is saying, and the Supreme Court does that. The Congress makes laws, but the Supreme Court actually defines them a lot of times for us and helps us to understand what those are. As we look at the next court case, McCullough versus Maryland in 1819, has to do with banks. Says, let the end be legitimate, and all means which are consistent with the letter and spirit of the Constitution are constitutional. Chief Justice Marshall invoked this phrase to establish the right of Congress to pass laws that are necessary and proper to conduct the business of the U.S. government. The court upheld Congress's power to create a national bank. And so it was very important for them to be able to do that because they're doing many other things dealing with money. So they needed a bank as well. Ruled that the states cannot tax the federal government because the power to tax is the power to destroy. I want you to see this statement made by Chief Justice John Marshall. Although among the enumerated mentioned powers of government, we do not find the word bank or incorporation. We find the great powers to lay and collect taxes, to borrow money, to regulate commerce, to declare and conduct a war, and raise and support armies and navies. But it may, with great reason, be contended that a government entrusted with such ample powers must also be entrusted with ample means for their execution. The power being given, it is the interest of the nation to facilitate its execution, meaning it was important to be able to have facilities that could actually handle the business of the government, and that's why banks were very important. But states could not tax that bank, and so that's what we're looking at with McCullough in Maryland. The next case is Plessy versus Ferguson, 1896. Separate but equal case is really what we would call this. Police arrested Homer Plessy for refusing to leave a railroad car that prohibited colored people. Under Louisiana law, Plessy was colored because he was 1/8 black. The court ruled that the race-based Jim Crow laws did not violate the Constitution as long as the states preferred separate but equal treatment. This is a very interesting case, which is just really caused a lot of problems throughout America. It's a shame that it actually came about, but these are the types of things that you would see. Drinking fountain, here's for white people, here's for colored people. Bathrooms would be the same type of way. This was a huge issue, and it was saying, okay, there would be railroad cars for white people, and there would be railroad cars for colored people. And this was a constitutional law, or that this was actually law because a case was made, and this was the verdict on that. And so when people go to trial and there is and they're before court or Supreme Court, and that court decides something, that means that's the law for everybody else too. which is a very odd thing, but that's exactly what we're looking at here. And it's a good thing if it's done rightly, morally, ethically, all those types of things. But this was one of those that was a very interesting case and just kind of went the wrong direction. I just want to show you something really quickly. This is the case, and it kind of lays it out there again. But I just want you to see, just look over. This is Plessy on the right, was 1/8 black and 7/8 white. Under Louisiana state law, was classified as an African American and thus required to sit in the colored car. And this court case pushed that through. Pretty sad. And there's going to be some things that change it, of course, with desegregation in the future. But this was a constitutional thing. Shank versus United States, 1919. Speech that presents a clear and present danger to the security of the United States is in violation of the principle of free speech as protected by the First Amendment of the Constitution. During World War I, sorry this is so small, but I want to try to put this all in there. During World War I, 1918, Charles Shank was the General Secretary of the Socialist Party and was arrested for distributing literature discouraging young men from enlisting in the armed forces. The basis for his opposition to draft and enlistment was the first clause of the 13th Amendment, which prohibited slavery or involuntary servitude. Shank appealed his conviction, and the case went to the Supreme Court. The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. Distributing literature during peacetime would have been an entirely different matter. But in time of war, Shank's actions, according to the court, presented a clear and present danger to the security of the United States. To kind of help you understand this a little bit more, I wanted to show you this picture. This is the place known as Surrey Garden Music Hall. This is in England, and this is the place where Charles Spurgeon in the mid-1800s went and preached there. Now, he went there because his church was growing so much that he was pastoring, and this place could hold over 10,000 people, and that's how many people that he was preaching to. And so they went there, and it was first Sunday preaching, and it was just going to be packed out, and it was packed out. And while everybody was waiting for Charles Spurgeon to step up to the pulpit and to preach, some people yelled out in the auditorium, "Fire, fire, the place is collapsing." And because of that, people began to run outside. They tried to get downstairs as quickly as possible. And what happened was 7 people were trampled and killed in that building because some young hooligans or whatever you want to call them decided they were going to play a prank, and they started yelling fire. People tried to run out and killed 7 people, injured several others. And so this Shank versus United States has a lot to do with that. You can't just yell things. You got the freedom of speech, but you just can't yell things because it'll put people in danger. So unless there's a clear and present danger, you can't just yell things and cause a riot or cause havoc, whatever it is. And so that's what we're looking at when we're looking at this case. Gitlow versus New York in 1925. Gitlow, a socialist, was arrested for distributing copies of left-wing manifesto that called for the establishment of socialism through strikes and class action of any form. Gitlow was convicted under a state criminal anarchy law, which punished advocating the overthrow of the government by force. At his trial, Gitlow argued that since there was no resulting action flowing from the manifesto's publication, the statute penalized utterances without propensity to incitement of concrete action. The New York courts had decided that anyone who advocated the doctrine of violent revolution violated the law. Here's a picture of him on the right. This has a lot to do with what we were just talking about in the previous slide as well. You cannot just put stuff out there and it causes anarchy or it causes an overthrowing of the government by force or rioting, those types of things. That would cause it was inciting things that should never ever take place, and so there was so the courts decided that anyone who advocated the doctrine of violence revolution violated the law. All right, and then we go on to one that's probably a little bit more familiar with all of us is Brown versus Board of Education of Topeka, 1954. The doctrine of separate but equal has no place. This unanimous decision marked the beginning of the end for the separate but equal era that started with Plessy and the start of a new period of American race relations. Desegregation of public schools began, as did resistance to it. 10 contentious years later, the Civil Rights Act of 1964 made racial equality a matter of federal law. If you ever get a chance to see the movie Remember the Titans, it is one of the great movies that helps you understand what was happening here when there was desegregation that took place and bringing in people from different ethnic backgrounds into one school. And it was just, it's an amazing movie to watch if you ever get a chance. But it's kind of this picture here we see how the high court banned segregation in schools, and so in public schools. And so this was a great and amazing thing that took place. Yes, there was some growing pains. Yes, there was some hurt feelings and some offenses that were made to certain people, but a great thing when segregation was banned. Just a great thing in America. And of course, you can talk to many older adults and they can help explain some of this because they went through it in their lives. And so it's kind of neat to hear those very things shared. Let's continue on with Gideon versus Wainwright, 1963. Defendants in criminal cases have an absolute right to counsel. Too poor to afford a lawyer, Clarence Earl Gideon was convicted for breaking into a pool room, a felony crime in Florida. He appealed to the Supreme Court, which ruled that the government must provide free counsel to accused criminals who cannot pay for it themselves. At first, the ruling applied to felonies only. It was later extended to cover any cases where the penalty was 6 months imprisonment or longer. And so here's a picture of Clarence Earl Gideon. He was a guy that just really didn't have a lot of money. He breaks into this pool room, felony, and so what this case was all about was having the right to counsel. Even though you can't afford it, you can have free counsel that can be given to you. And so this is what this is all about. Miranda versus Arizona, 1966. This is a very interesting one. You have the right to remain silent type case here. After police questioning Ernesto Miranda confessed to kidnapping and raping a woman, the court struck down his conviction on grounds that he was not informed of the Fifth Amendment right against self-incrimination. Hereafter, the Miranda warnings have been a standard feature of arrest procedures. Here's a picture of Ernesto Miranda, and you've probably heard the word Miranda being given before. Miranda rights, things like that. And here's what they are. This is very, it's amazing. From this court case, here's the Miranda warning. You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to talk to a lawyer or have him present with you while you are being questioned. If you cannot afford or hire a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. Waiver. Do you understand each of these rights I have explained to you? Having these rights in mind, do you wish to talk to us now? You've probably seen this in any cop shows or any lawyer type shows, but this is where the Miranda warning comes from, and the word Miranda comes into the court systems, and so or into the policing systems as well. I just think it's pretty fascinating when you look at all of it. This is Roe versus Wade, 1973. This case is very popular for us today and extremely controversial. We see here the constitutionally implied right to privacy protects a woman's choice in matters of abortion. Norma McCorvey sought an abortion in Texas, but was denied under state law. The court struck down that law on grounds that it unconstitutionally restricted the woman's right to choose. The opinion set forth guidelines for state abortion regulations. States could restrict a woman's right to choose only in later stages of pregnancy. Later modified but not overruled, the decision stands as one of the court's most controversial. And here you see Norma McCorvey on the left, and you see her lawyer on the right. And actually, she took on the alias Jane Roe, which is kind of the opposite, or the female version of John Doe, Jane Roe, and that's what she took on. And she became a person who was living in a homosexual lifestyle during this time, and kind of just thought women had all these rights. But very interestingly, in 1995, she gave her life to Jesus Christ, became a Christian, and she regretted everything that she had been a part of in her life previous to this. I want to show you one of her quotes. I think it's safe to say that the entire abortion industry is based on a lie. I am dedicated to spending the rest of my life undoing the law that bears my name, Norma McCorvey. And as I said earlier, she went by the alias Jane Roe during that time. That's what she's talking about, what bore her name. All right. Let's look at the United States versus Nixon. Maybe you've heard of the Watergate scandal. This is 1974 case. Neither separation of power nor the need for confidentiality can sustain unqualified presidential immunity from the judicial process. President Nixon sought precisely this type of immunity. Rather than relinquishing the famous White House tapes during the Watergate scandal, the court unanimously rejected his plea as an unconstitutional power play. The House began impeachment proceedings shortly after, and 2 weeks after the ruling, Nixon resigned. Here's a picture of Nixon. Richard Nixon was a Republican, of course, president, and what took place is burglars went into the Watergate building, which was the Democratic headquarters, to take some things, broke in to take some things and things like that. Well, Nixon was connected to these guys, and so he had tapes to prove his connections, all this kind of stuff. But he said, I'm not giving this up because I have this executive right to my privacy. And what the court ruled is, no, you don't. You don't have any rights to privacy. Actually, you need to hand all these things over, and so that's why he resigned. He was impeached and resigned. That's what happened with him. I thought this was kind of interesting. I wanted to show you this, just something that somebody made. I erased 18 and a half minutes of tape that he had. Hillary deleted 30,000 emails. Who's the crook now? A lot of people would say, I'm not showing this to just bash Nixon or bash Hillary or anything like that. But what we do see is that there is a standard in most voters in a lot of ways of saying, okay, this is what's wrong with society, and this is why Hillary did not make it into office, probably for the most part, is because she did hide things, and it was obvious. And so you can't do those types of things and really be presidential in any ways. And so it's pretty sad what we've seen over the years. Presidents have done very unpresidential things, and even our president that we have now has done very unpresidential things. And so we need to pray for these people and keep them constantly in our thoughts and in our prayers. All right. Let me leave you with that. This has been Religion in the Public Square, looking at the Supreme Court cases that changed America. Good to be with you, and we'll talk to you soon. All right.